Greetings. My name is Anish Juneja, and I would be talking about the case Finance Ministry versus Manifattura Lane Marz Otto, or as we would like to call it, MLM, on behalf of my team. The government of Italy imposed an administrative services duty over woolen items that were imported from Australia by MLM. As a result of it, MLM litigated the government, appealing that the service duty charged by the government has violated Article 3, subsection 1b of the General Agreement on Trade and Tariffs. The government took a decision to dismiss the case on the argument that the Article 3, subsection 1b was not directly effective and on the basis that the Italian Parliament had not approved the implementation of the legislation. The issue at hand was whether there was a direct impact of Article 3, subsection 1b of the GATT or not. The court held the decision in favor of MLM, saying that the Article 3 of GATT was directly effective. While ruling out their judgment, the court adhered to the following laws. The first law stated that the GATT Article 3 institutes the excessive amounts of charges to be imposed by the contracting states. The second law was Italy's Law No. 195 of April 1950, which stated that the GATT was completely implemented. The third law stated that the treaty provisions that order that a state is not to act do not necessitate the state to be fully implemented. The GATT is entirely a part of the legal system of Italy. This was given as an explanation for the court's judgment. Since the Article 3 is a prohibition requiring the state not to act, there is no need for specific implementation of the legislation. It is directly effective and may be invoked by private persons. The General Agreement on Tariffs and Trades was framed in 1947 at Geneva, Switzerland. The outline of rules defined the manner by which the trade relations were directed between the contracting parties, while the organization was a medium of trade-related negotiations and a mechanism of amending and imposing the GATT rules. The purpose of the rules of GATT is to provide member states of the WTO with equal right to use the markets, mutuality in trade concessions, and for apparent and steady circumstances for trade. Moreover, the other purposes of these rules is to progressively liberalize the trade all over the world. There are various GATT provisions that are directly effective. Individuals along with other signatories may depend on GATT provisions to test the actions taken by the contracting party. The provisions that are openly operative ban the state from taking action which opposes the general agreement that is directly effective. Individuals may only challenge the provisions that are required for a contracting state to take some of the positive action if the state accepts applying the legislation approving such a trial. Article 3 is related to the national treatment on the processes of internal taxation and regulation, according to which the contracting parties are required to recognize that internal taxes and other relevant charges and the rules and regulations that affect the internal sale and purchase should not be realized to imported and local products in order to provide defense to the local production. In addition to it, the products of the area of contracting party that may have been imported in the territory of any other contracting party will not be considered directly or indirectly to the internal taxes or other relevant duties of various kinds as compared to the similar domestic products. Furthermore, none of the contracting party is required to put on internal taxes or other internal duties to the imported and local products. GATT Article 3 states that WTO members should provide similar national treatment to all the members. Article 3, subsection 2 relates to the internal taxes and duties and specifies that WTO members should not put on standards greater than which have been imposed between imported goods and local goods, or between imported and other goods in the competitive range. In this case, the government of Italy imposed administrative service duty on the goods imported from Australia, which was in contravention of Article 3 of GATT. The judgment was also induced by the law number 195 of Italy, which stated that due to implementation of GATT in general, the entire agreement had been under implementation. The legal system of Italy completely follows GATT and Article 3 of the GATT, which creates a prohibition for the state not to act in such matters, meaning that there is no requirement of specific implementation of the legislation. Furthermore, there should be non-discrimination at the time of conducting international trade. The company had the right to take strict legal action against the government. The government of Italy imposed administrative service duty on the woolen goods which were imported from Australia by MLM. The company prosecuted the government by arguing that the duty imposed by the government had violated Article 3, subsection 1b of GATT. As a result, the government dismissed the case on the argument that there was no direct effect of the Article 3 as the Parliament of Italy had not adopted the implementation of the legislation. The court gave the decision in favor of the company and provided reason that GATT is entirely a part of the legislative system of Italy, and it is not essential that specific implementation of Article 3 should be followed by the Italian government. The government of Italy follows provisions of the GATT, and that is why it must not impose such service charges on the goods that are imported from outside the country. The decision of the court was deemed fair, as according to the law number 195 of Italy, Article 3 proved to be directly effective on the goods imported in the country. The following is a list of the references which were used while researching about this case. In the end, I and my team would like to thank you for giving us the opportunity to know and research about this case.